right. So Mark, welcome. This is our fourth podcast. It's me, Derek Fahey, and Mark Terry. Say hi, Mark.
Hey, everybody.
All right. We're gonna do first thing is we want to do these questions from that they came up with from ChatGPT.
All right.
All right. So gave me 5 questions to use at the beginning of a podcast, but I need to get it. It gave me like long questions, so I need to kind of clean it up a little bit. So I'm going to change it to five questions that
I got a few here as well. Yeah.
Okay.
First, I'll go second.
Okay. Quick questions for quick answers, short answers. By the way, for people who don't know what ChatGPT is, you can basically input any question you want, and it gives you some answers. Sometimes it's good, sometimes it's bad. But these 2 questions I put in gave me really bad answers. I put 5 questions to talk about at the beginning of a podcast, and then it said, "Tell us a little about yourself and your background," which I don't really want to talk about. But actually, no, Mark, tell us a little bit about your background since we're here. Quick 30 seconds while I figure this out.
My background. Okay. That's an open-ended. So I'm gonna go somewhere a little bit different with that question. Okay.
Sure.
So I like you, I'm a third culture kid, right? Which is defined as someone who accompanies their parents into a new culture, right?
Okay.
My parents were Peruvian, and they came here to this country, and so I grew up in a Peruvian household. I was born and raised in Miami, so I had one culture at home, which was the South American culture, and then I had the American culture at school and at work. And my wife is also a third culture kid. She's French. She had a very similar experience. So we have a lot of fun together talking about the experiences of having immigrant parents.
Yeah. Yeah. So funny you say that. I'm an immigrant too, from Trinidad. And for many years, nobody understood my dad because his dialect was so thick. And sometimes my wife and my in-laws, like, they'll say something in his accent, not realizing it's like a regular word. And it's just really funny because like, for instance, the word mango in Trinidad, and then when you're from Trinidad, you say mango, they hear that word and they're thinking like, what the hell is it talking about? What is mango? What is mango? And then my wife will look at them and be like, oh my God, this is so embarrassing because they can barely understand him. And my dad is actually he speaks really slow, but some people have a hard time hearing him. But anyways, that was kind of fun to talk about.
Yeah.
So I'll ask you the answers I got are the same ones I asked last time. But here's one. What's something you're working on that you're excited
about? Oh gosh, so many things. Let me just I'll just sort of pick one at random that I'm working on right now, which is a kit that you use when you smoke cigars. Right?
Okay.
So, you usually need all these things when you smoke a cigar. Like, you need a lighter, right? You got the cutter, right, that cuts the tip. You got this thing called a spike. You need something to strike the match on, or you need a match as well. You need an ashtray. So no one offers like a whole kit. So I thought that was super cool because it's got the hallmark of a great invention. It's something that's super simple. It's hard to believe no one's thought about it before.
Yeah.
So
is that a published thing, or is that a published thing you're working on, or?
Pardon me?
Is that like a published thing, or is that like a device you're creating yourself?
Oh no, it's something I'm working on for a client.
Oh, cool. All right, for me, I'll tell you what I'm working on. It's kind of fun. It's not even work related. Is we're fixing up a detached garage, and they're like raising up the roof. So just like fixing that and seeing that roof being raised is actually pretty cool. That's kind of fun.
So they're not dismantling the roof, they're actually
Oh,
detaching it, they're raising it up, and they're putting some more wall in there
they're actually, well, they took off the roof and now they're like
in one
putting in,
piece?
no, they totally have to redo it.
Oh, God. Okay, they
Yeah.
dismantled it. Okay,
Yeah.
got
They
it. Got
dismantle it and then we're adding in concrete block on top. You got to tie it in and then they put the roof back. They're going to put another roof on. It's pretty similar.
it.
And
Got
yeah, that's kind of fun. It's very low, slow, long process, but it's a lot of fun.
it. Oh,
So
man.
yeah.
Seems like a big project.
Yeah, oh, man, it's crazy. Anyways, today's podcast. All right. We are talking about Zarna and the Dawn of the Dawn and copyright of material or works that have been generated from artificial intelligence, right? You know, we're sitting here playing with ChatGPT, which both you and I use for in a lot of different ways. And what I find really cool about ChatGPT is you're able to, which is just generative AI, right? Which basically generates some sort of content. Is it really helps you when you and I were talking about this? It helps you in different things. If you are drafting a document, it helps you get started. It's not perfect, but you can certainly draft pieces of a document. Maybe if you can say, hey, give me a, give me a, give me 5 questions to talk about in a podcast. It'll give you 5 different things, right? So let's talk about Zarna and the Dawn. That is a kind of a fun case. So just by way of background, the Zarna and the Dawn was this comic book essentially that was created, which had some images that were created by artificial intelligence. And then the author of the book also put some text in there and arranged the photos or the artificial intelligence, the content or the images that were generated from artificial intelligence software to create this book. They filed an application with the Copyright Office and they went back and forth. And ultimately, the Copyright Office decided that certain portions of Zarna and the Dawn book were actually protectable and some were not. And did you read that? Did you read the opinion, Mark?
Yeah. Yeah.
Okay, cool. Well, what are your initial thoughts, man?
Well, my initial thought was that this is not, I don't think this is the best case for this situation. What I would have liked to see would have been a case where the fact pattern was, hey, you just give the AI a few prompts and it creates something for you. And then the question is, can you copyright it? If so, who's the author and so on and so forth. This one involved the author actually making quite a few selections and adding some originality to it.
Yeah.
And I think that kind of muddied the opinion a bit because we could say that all of those contributions that were made by that author were contributing originality and content to the final products.
Yeah. Well, honestly, I thought it was very helpful for me actually, because the rule basically is you must be a human to create the work that's copyrightable. So you remember that PETA case where there was a monkey that took a photograph, like a selfie of himself,
Yeah.
right? And the Copyright Office and the district court actually held that was not a work that could be protected with copyright law because the author, the monkey, wasn't a human. So even though it was, he took the photograph, it wasn't a human. I thought that was interesting. So in my opinion, I thought that the Copyright Office actually did a pretty good job. And here's why, because they actually just made the distinction. They said, hey, the words that you create are protectable. They said the content, the arrangement of the images with the words are protectable.
Mhm.
But they said the images by itself, even though I actually read the opinion, is they said that even though they were, the person went through multiple prompts to get to the image, even though they went through that, because it was like a mechanical reproduction and the person did not have the control over it, that was not protectable. In fact, when I first read it, I said, when I read it, they said the applicant, the person that was trying to protect the artwork, they actually said that they made the argument, well, just like a photograph, right? When you take a photo, it's you're using mechanical means to create a photograph. It's just kind of the same thing, you're creating the photograph, you're selecting the light, you're selecting, the angle that you're using. Our applicant made the argument that doesn't, it's very similar. Now, in this case, it's analogous. They argued that because the applicant actually went through hundreds of prompts. They would put a prompt in, get 6 images, put another prompt in, and kept on, kind of going down the rabbit hole to get to the final image. The Copyright Office said, even though you went through all those reiterations, they said that's not enough. So what I think is going to be interesting is to see this case. Imagine you have an artificial intelligence software that you can draw a drawing with a cup in your hand, and then maybe artificial intelligence will create an image in the style of Shakespeare wearing a hat or something like that. Would that be protected? That's where I think it's going to be more of a gray area where you can see where there's going to be artificial intelligence, artificial intelligence type of software that is going to be more selective. It's going to actually have more, your own mental conception to create it. So that's kind of what I thought was interesting. I thought was actually fairly helpful, actually.
Yeah, I was hoping for a decision that would apply directly to DALL-E, which is one of the OpenAI image models. But that didn't seem to be that one. And though you could potentially say that some of that, there was some dicta in that response that you could potentially say applies to DALL-E, but I really would have liked to see that.
Yeah.
And here, you know what? I'm gonna share my screen here.
Okay.
So I can show you. Oh, I think you need to enable screen sharing.
Sure. Here you go. Done.
Okay. Let's see here. Share screen. Okay. Okay. So here you see. Can you see my screen?
Yep.
Okay. So here, this is directly from the OpenAI website, and this is DALL-E. And so you can see, so here's a perfect example right here. The prompt for this one here was an oil painting by Matisse of a humanoid robot playing chess. And you can see the image there is right on. It's right on.
Yeah.
You got this one. I really like this one over here. This is a photo of a white fur monster standing in a purple room. There you go. And then lastly, I like this one here as well. An armchair in the shape of an avocado.
Yeah. So
using just a few text prompts, just a few of them, and it just automatically creates it. I would have liked to see a response that touches a decision that touches on that.
Yeah. I do think that, I think that I wasn't sure, but I think that it does talk about that. I think it says that how the author says that, they put certain prompts in, and then they would get a response, and then they would say, well, this fire breathing dragon has got, or they would actually take that image and then adjust it even further. They actually did a whole bunch of reiterations.
Mm-hmm.
So
you can add more parameters to it, right?
Yeah, exactly. In fact, you may have seen, so just to kind of reiterate, the opinion really said there's 3 kind of groupings, right? There's the words which the author created, that's protectable.
Mm-hmm.
They have the images that were created by the artificial intelligence from the prompts of the author, that's not protectable. Mm-hmm. But they also said that the third part, which was the arrangement of the images and text, the overall arrangement was protectable. Now, what I thought was kind of cool is they also talked about where the author photoshopped like the lip. I don't know if you saw that, they actually took the image of the actual person, and like let's say the image that they had, and the author made like a little, just like with a lot of AI, they may not have a perfect image. It may have like a lip that's screwy, or we were playing around with it and we asked it to, do like a fire breathing dragon, and the fire was coming out of the dragon's butt. It was something as opposed to the mouth, like this weird stuff, right? And but the author took a little bit of like, they corrected it. They used like Photoshop and corrected it a little bit on the lip. And the Copyright Office said that's not enough to be protectable. Even though you made some Photoshop of it, it's not enough to be protectable. So that also is kind of a kind of an interesting topic, as to talk about like, well, if I change the content, do I get protection? In in this case, they said no, because it wasn't enough. So just some more stuff to think about.
Yeah.
Yeah. Okay, so you may have read also the Copyright Office came out with that the policy statement March 16th, and they talked about this. They kind of talked about this, and one of the things, interestingly, is they kind of referred to back to this case from the 1800s, that it's Burrow Giles lithograph versus Sereny. It's a case where back when when people started creating photographs, this gentleman took a photograph and he copied the photograph of another person, and the other person sued him, and the person who copied the photograph said, no, this photograph's not entitled to protection because a human didn't create it. And the Supreme Court actually said no, because when you take a photograph, you are actually choosing the image, right? You're actually choosing what you want to see. You're choosing the lighting, and in the policy statement, it came down to, and they cited this quite often, is they said that how it's not, if whatever you're doing, if it's just a mechanical reproduction, you have no original mental conception of it, that's not enough, right? Whereas if you do Photoshop, or if you do if you do take a photograph with the camera, you have a mental impression. Now, to your point, I think it's gonna be really interesting. I'm sure you can think of a fact pattern with DALL-E, where maybe you actually insert your own photograph and they maybe generate something based upon it. That's what I think is going to be the next step, where people are going to have issues.
Oh, absolutely. And there is a piece of software that does it. I think it's called DALL-E Plus or Doll Plus.
Okay, cool.
You have to pay for that one, so I don't have access to that.
Yeah. So, I was actually listening to another podcast actually, and there's lawsuits coming out where Getty Images is suing the makers of, I want to say it's Midjourney, I believe, or they're suing certain generative AI software companies, because they're using the content that they use to create the data set from which they're producing the content.
Yeah.
They never got a license for it. In fact, I think the lawsuit kind of basically talked about, you could see a reproduction of the Getty Images symbol in one of the images. So they were like, Getty Images, which is notorious for suing for copyright infringement, said, listen, it's like you're creating a whole new product, but the content that you created, that you use to train your system with, you never had a license to do that. Like, so you have to copy it to do that, I thought that was really interesting,
Oh, that's super interesting. That seems like it rests on the question of whether or not the images created by Midjourney are considered a derivative work of the Getty Images, right?
Yeah, for sure.
They're not reproductions, right? They're not performing the Getty Images. They're not distributing the Getty Images. They're creating the only right that is under the purview of the copyright that the plaintiff can use in that case would be the idea that it's a derivative work.
Yep.
And I'm not sure. I'm not sure how I feel about that. I mean, on the one hand, clearly the Getty images are being used to create Disney works. On the other hand, it is perfectly allowed for anyone to view a work by someone else and create your own work based on that, as long as it doesn't rise to the level of being a derivative work. So when I have clients that always ask me about that concept, the example I always give them is that, if Shakespeare still held the copyright for Romeo and Juliet, he would not own the rights to the general idea of two teenage star-crossed lovers who come from warring families who end up dating and getting into a tryst. He doesn't own that general idea. Anyone can write a story that follows those same steps. What you can't do is, and what would be considered copyright infringement would be, actually writing the words, Romeo, Romeo, where art thou, Romeo? It's something to, something to that level would be considered copyright infringement.
Yeah.
So I'm not really sure how I feel about that.
Yeah, an interesting kind of case. Also, I was listening to another podcast, and Adobe, I think it was either the CTO of Adobe or the CFO of Adobe, he was talking about the software that they're using, some sort of research and development software that's a generative AI software for Adobe. I'm really not sure what it is, but he was saying that, Adobe aggressively, he used words like aggressively and relentlessly pursued the licensing rights for that beforehand, right? So they actually took the time to get the licensing rights for whatever data they were training their software on beforehand, so they wouldn't have this issue. So it is a really interesting topic. Normally I would say I'd be surprised if it goes to trial, but I think the money is so big that they may actually need to go to the Supreme Court and get an answer on something that says, hey, listen, if you train your data set with our content, is that considered some sort of infringement on some sort of matter? I've been really curious to that. And I know it's a very specific question and very fact specific, but I'd be really curious because this generative AI is only going to get better and it's not going away. I mean, I use it more and more every day, quite honestly.
Yeah, I mean, it's definitely a disruptor.
Yeah.
It's disrupting the industry for Getty Images and all of the other image providers. It's going to destroy their business. I mean, absolutely destroy it, because no one is going to want to use their images anymore if you could just create your own.
Yep.
For free.
Yeah.
Right? And very high quality, as you saw when I shared my screen. And I don't think they're going to get a lot of love from the public, because so many people have been on the receiving end of enforcement from Getty Images and the other photograph providers that I don't think a lot of people are going to come to their defense.
Yeah. It's just really interesting. Yeah, I don't know either. I mean, I think there's always going to be a place for great original work. Obviously, that's not generative AI. Any generative AI is definitely not perfect. But Getty Images and other artists, they do use legally. They use the copyright laws to their advantage and get people to pay for their work, right? But I feel like I'm with you. I don't know how it's going to shake out, but it's really I'm really curious to see how it's going to change this industry, how the generative AI is going to change, this industry. Okay, for example, right? So you have a artwork that you're using in your book that is from some sort of generative AI, whether it's Midjourney or DALL-E or whatever the case, and then someone copies it, just the image by itself. And this image is like representing your book. It's kind of like been known to represent you. Well, to represent your book at the very least, and they copy it and use it on something else. I mean, technically, as of now, you have no rights, you have no copyrights to that particular image. So they can do that. Trademark rights, setting trademark rights aside. It's just a really interesting topic to think about.
I think it's yeah, I mean, look, in a situation like that, if you want copyrights, create your own work.
Yep.
It's real simple, pay a graphic designer, pay someone, or do it yourself. Create something that can be copyrighted.
Yeah.
Buy Adobe Illustrator, create your own thing, and then you can copyright it. If you're gonna have it created by an AI, you can't register it. I don't see any.
Yeah. Interestingly, one of the things that they said in the statement of policy that the Copyright Office put out is they said the Copyright Office gets 500,000 applications a year for copyright applications. And they were kind of alluding to the fact that they just can't handle, if people start filing applications and trying to get registration for AI generated images, they couldn't keep up. They're actually changing their application to request information about whether or not it was generated with the help of artificial intelligence. So you're going to start seeing that in the copyright applications, interestingly enough.
Interesting.
Yeah. Anyways, fun topic. Anything else to add, man?
Well, one of the things that that come to mind when I see what Getty Images is doing is what happened to Metallica when Napster first came out, right? Napster came out. Metallica was upset that Napster was distributing the Metallica songs, and Metallica themselves, as the copyright owners, sued not just Napster, but sued the end users, and which is perfectly legal, but they suffered an immense backlash for it, going after your own consumers. And I think Getty Images is experiencing that right now. They went after users of their images for so many years, and now they're experiencing a disruption, and I don't think they're going to get a lot of love from the public.
Yeah. It's kind of cool. I mean, I see two big, I guess in summary, I see two big, interesting areas for me is users that are trying to sue other people based upon content that the user created from the artificial intelligence, and then trying to figure out, hey, what is actually is it protectable? Is it not? But then also I see a whole bunch of other litigation, which I think is going to be more intense, which is with the Getty Images and the software creators of this generative AI and software, which is, hey, if you use my data, if you use my information to train your software, do I need a license? I just think it's going to be an interesting topic, and there's going to be something that's going to come up, because not every single generative AI software is going to go get a license from Getty Images or wherever the case may be. So
yeah,
that's what I think is going to be a big hotbed for litigation. So we'll see.
Yeah, it's cool. Going to be very interesting.
Yeah. All right, man. Well, great podcast. Well, with any closing remarks?
I don't have any.
All right, mine will just be get out there, create some stuff, and we'll see you next time. You can find Mark on Instagram at Mark Terry PA, and me at Derek Fahey PA, and you can find us both on plusfirm.com, www.plusfirm.com. Have a great everybody.
Have a good one.